Welcome to Planning for Protection.
Welcome back to Planning for Protection with attorney Jeff Ryder. Jeff is an elder law and estate planning attorney serving families across Carroll County and the surrounding Indiana communities. I'm Evan Mack, and today we're talking about one of the most misunderstood parts of Medicaid planning in Indiana, the 5-year look-back period. Jeff, welcome back, brother.
Hello, Evan. It's good to be back.
Good to see you, Jeff. So what does the Medicaid look-back period mean in Indiana?
Well, Indiana, as well as most other states, has a 5-year look-back period. If you make any transfer over $1,200 to anyone, really, during that 5-year period, except churches or a regular contribution to your church, then you have made a violative transfer that will disqualify you from receiving benefits for nursing home stays under the Medicaid program.
What kinds of financial decisions tend to create problems during the Medicaid review process, even when families believe they were acting responsibly or helping out a loved one?
Well, typically gifts. If people make gifts, they think they're doing a good thing, and they are. But Medicaid takes a different view of that. And they say if that gift totaled between any and all of your family $1,200 or more than $1,200, then you have created a 5-year penalty period from the date of the last gift that you made.
So families sometimes help the children or grandchildren with birthdays, tuitions, weddings, or informal loans maybe over the years. How closely does Medicaid review those everyday types of transfers?
Well, that's a very good question, Evan. Medicaid can and sometimes does ask for 5 years of financial records, and they are getting better and better at scrutinizing those records to determine have there been any transfers. So I don't recommend that people make any significant gifts if their health is becoming more fragile and they're getting older and they have that risk of needing to apply for Medicaid benefits.
Indiana families sometimes transfer farmland, homes, or other property long before the nursing home situation. What makes real estate transfers especially important to review carefully?
Well, I don't know that real estate transfers are significantly different from other transfers, but there is a very obvious paper trail with regard to real estate transfers because those deeds end up being recorded in the county where the property is located, and anyone and everyone has access to, including Medicaid, has access to those records.
If Medicaid determines that a transfer violated the rules, what actually happens next?
Well, that is a complicated question, Evan. So if the transfer has already occurred, say 3 years ago, I sometimes or often recommend that the recipient transfer the property back to the parent. And the reason for doing that is if the property is returned, the transfer, the penalty period is undone, and there is no longer a penalty period calculated because the property was returned. So that is one thing that we often do. But if you are already in the nursing home, we can also do what's called a half a loaf plan. And so say a person had no real estate and they had $200,000 in the bank. And they said, okay, the family came in and said, mom or dad's in the nursing home now. What are our options? What could we do? Well, one could be a transfer of about half of that asset to the family, and then a loan to a trusted family member for the other half of the money. So between the gift and the loan, the person would have less than $2,000 left in their account at the time that they're applying for Medicaid. And then the loaned money would be documented by a Medicaid-Compliant promissory note, one that meets all the bells and whistles that the Medicaid program requires, such as that there be substantially equal monthly payments over the period of the loan. There be a payback clause that if there is any money left payable on the note at the death of the person, the state of Indiana is the beneficiary of that loan, or the remaining portion of that loan. and we typically have an interest rate calculated at the applicable federal interest rate for typically a short-term loan. So there's a bit of interest that's payable on it, and that cannot be forgiven. So it's got to be paid, and it has to be paid to the state of Indiana if there's any Medicaid money paid. And you might ask, well, how long does this loan last? Well, we tailor it to make it fit the circumstances and the assets of the person. So in our illustration, we just did a $100,000 gift. So I'm going to put $100,000 in. And then you compare that gift with the average cost of nursing home care in Indiana. And that's a number that's published by the state. And it's going to be changing July 1st of this year. But $100,000 divided by $7,651 is 13.07 months. So in this particular case, we would tailor the loan payments to be paid over 13 months. And we'd probably round it down a little bit to make it an even 13 months as opposed to the 0.07 months. The payments, coupled with the income of the person, are tailored to be almost enough to cover the complete cost of the private pay rate for that 13 months that the person is in the nursing home. And so the family ends up getting $100,000 as a gift, even though the person is going to the nursing home, because the old gifting rules are what apply if you're doing it as a part of a Medicaid-approved plan as you're applying for Medicaid. So it's a variation on the 5-year rule because you get to take advantage of the older rule, which looked at the amount given compared to the cost of nursing home care. And the state said, well, if you don't give very much, you couldn't have paid very long in the nursing home. So they tailor it to match the amount of the gift, or the amount of the cost of care is tailored to make the penalty match the effect of having made the gift.
Timing does seem critical in these situations, though, Jeff. What planning opportunities are available if someone starts preparing before there's an immediate long-term care crisis?
Well, just like I outlined, there are several exempt transfers that a person can make, such as paying for their funeral arrangements for them and their spouse. In addition, at the present time at least, there is an option to pay for burial arrangements for children and their spouses, and siblings and their spouses. And if they do that, the burial arrangements have to be pretty specific. They can be things like vaults, caskets, opening and closing the grave, headstones, bases for headstones, inscriptions on headstones, but not things like services, embalming, or the memorial service, things like that. It's only things that will go in or on the ground for the family. But for the applicant and their spouse, it can be everything: the services, the embalming, all that stuff. Another option that they could consider doing is transferring or purchasing a vehicle. And oftentimes that vehicle might be one that a child would appreciate having and driving. And as long as that vehicle is available for the transportation of the person in the nursing home, it can be exempt. So I've had people that have bought relatively expensive vehicles, and their children, of course, drive them, and then they use them to transport their loved one who's in the nursing home.
Jeff, do you have an example of a situation where a family unintentionally created Medicaid problems because they didn't fully understand all these look-back rules?
Oh, many, many, many examples. I get people not infrequently who have, it's not frequent, but occasionally I get people who've already applied for Medicaid and been denied. And then they're coming in to say, we didn't think this was going to be this hard. What are we going to do here? And so we then discuss these different options and give them guidance on exactly what the rules are and how they can utilize the rules to maximize the benefit that can be paid to the family as opposed to paid to the nursing home and or the state of Indiana.
For someone listening right now, Jeff, who may have transferred money or property in the past few years, what steps should they take before applying for that Medicaid or making additional financial changes?
Well, number one, they should try to be very careful to keep good records of how much was transferred and the date on which it was transferred, because those become key. And then they really should come and see a qualified elder law attorney. Of course, I hope they come and see me, but they're going to be needing to get good guidance and have their options explained to them so they don't end up being denied. If they make a large transfer, and then they apply for Medicaid, that penalty period can extend indefinitely. So you don't want to apply for Medicaid if you've made a large transfer without seeking guidance before you apply.
Good stuff, Jeff. Thank you so much.
You're welcome, Evan. Thank you.
All right. That's it for today's episode of Planning for Protection. If you'd like to learn more about attorney Jeff Ryder and his work at Jeffrey C. Ryder Attorney at Law, LLC, visit jryderlaw.com. Thank you so much for listening. And don't forget to like, subscribe to the show, and leave a review if you found this episode helpful as well. And we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.